How's everybody doing? I'm very glad that you get ethics credit for this. If that puts the people in the seats, that makes me all the happier to hear this story I have to tell you today. Well, thank you to the CUA Innocence Project, the Criminal Law Society, the Legal Services Society, and SPIL, who I was the co-chair of the SPIL auction in 1997. We raised $30,000, which I was happy to say. It's an honor to come to you and talk about this very important case. I did a presentation on this case about 18 months ago, so I apologize for any redundancy, but for those of you who weren't here, get ready and buckle up for a very interesting case. I'm a 1998 CUA grad. My 1L summer, I spent interning at a public defender's office in Alexandria, Virginia, and then I did D.C. law students in court as a third year. And from those two experiences, I knew that legal services to the indigent was going to be part of what my practice was. Prior to being at the very large firm I'm at now, I was a public defender in Brooklyn, New York with legal aid. And I defended the guilty, the very guilty, and the extraordinarily guilty. But it was an incredible experience to fight for the underdog every day and have over 100 felony cases at any one time. It was an incredible experience. Did many jury trials, stood up and said my name in front of a jury. There's really truly no substitute for that. So while you're still young and you can get out of law school, try to work for a district attorney's office or a public defender if you have an interest in criminal law. I'm currently of counsel at K&L Gates in Washington, D.C., a large international law firm with 36 offices across the world. My practice is typically white-collar criminal defense and other government enforcement matters. But I do a lot of pro bono at the firm. I did about 500 hours last year, which is by far more than any other attorney in the office. I'm a member of the firm's pro bono committee, which means cases that come in, we screen to see if we could take them. And now that brings me to my favorite pro bono case of all time, Alfred Dwayne Brown. Alfred Brown was swiftly convicted and sentenced to death in 2005. There he is right there, getting arrested. He was on death row in Livingston, Texas. And he had a lawyer. His death row neighbor called him and said, "Man, where's your lawyer? Aren't you going to file some appeals?" And Alfred said, "Nah, man, I guess I'm just going to be executed. I don't have a lawyer." That neighbor made the best call of his life because he called the Texas Innocence Project. Here you go, Innocence Project. And saw to it that his story got told. And a blast email was sent to large firms that have the capability to handle these types of cases. And we took the case right away. And I was staffed to lead it because of my experience as a public defender. And we initially took the case because of the compelling mental retardation claims, of which I'll speak about later. But then the first time I went to death row, I knew instantly that he was innocent. And you see, working in Brooklyn for a couple years, your bullcrap meter is very high. You can tell right away if someone's lying to you, if someone's telling you the truth, and typically if they've done something wrong. And I knew from the moment I met this guy that he was innocent. And now, through years and years of investigation, we've now put the facts together with that gut feeling. So there he is right there. That was taken at death row maybe about a year ago. And right now I have to give a shout-out to a particular 1L who's here, Craig Gaver, in the third row back over there. He was with us during this picture taking right here, and was actually at death row for a very critical part of the case. And he's an awesome 1L. You should go talk to him afterwards. And I'll give you the firm's credit card, and Craig can buy everybody drinks after the presentation. Alfred is... I really have almost no words to say how much he means to me as his attorney. He's compared frequently to Lenny of Mice and Men. He can't read or write. The youngest of 4 kids. He was the result of an affair between his mother and her work supervisor. Alfred's father introduced his mother to crack. She once stole Alfred's shoes to sell them for drug money, and she would later sell her own self for crack. They moved from a trailer in Louisiana to a string of apartments in Houston, to the worst public housing complex in Houston called the Villa Americana, or the VA. I'll show you that later, where drugs, violence, and murder were commonplace. He was raised by his sister primarily. He was very quiet, didn't speak at all until he was 4. At the age of 11, he went to move to Louisiana, a small town called Morrow. And while he was there, this was the best time of his life. Simple, slow-paced. He got to work on cars and go on a crawfish boat. He was reading at a kindergarten level even as a teenager. He's got very few friends, often targeted, very easily taken advantage of. This trend continued in a very bad way when he went back to Houston when he was a teenager. And that's where he met these 2 guys. These are their mugshots. They're meant to look really bad, but these are the bad guys. These are the the two men who were convicted with Mr. Brown in the crime in this case. Let me go to the next slide. There was a botched robbery that occurred at that check cashing place right there that's in the box there. First, before they went to that check cashing place, however, they went to a different place to try to rob it. But the owner of that place cocked his gun, and the guys ran away. So then they ultimately went to this place to go rob it. It was supposed to be an inside job. The clerk who was working at that location was going to help them get into the safe. But she got nervous and called in sick. The actual clerk showed up to work on time. She tripped the silent alarm, and the cops came. The next slide. And in a horrific, terrible tragedy, Officer Charles Clark and Alfredia Jones were shot. There is no dispute, if you go back 2 slides, there's no dispute, just one more, that these two men right here, Deshaun Glaspie, the gentleman on your right, and Elijah Joubert, the gentleman on your left, were involved in this case. In fact, the man on the right there, Deshaun Glaspie, cooperated and testified at the trial of Mr. Joubert on the left and Mr. Brown, who were tried separately. Mr. Glaspie received a 30-year sentence for his crime. Mr. Joubert went to trial, was also sentenced to death. But there was always, who was the third person? And when I got this case, coming up on 3 years ago, I wondered who was that third person if it wasn't our guy. And so that was my sole goal, to find out who that third person was. But how Mr. Brown got involved in this case is actually quite sad. Glaspie, on your right there, was interrogated first by the police. He was found in a hotel maybe 2 miles from the check cashing place with a gun on him, smart criminal. And he lied and lied, said he hadn't done anything. The cops had heard some noise. Some witnesses say that Mr. Brown was seen at the Villa Americana apartments that day and began to inject his name into the discussion, saying, we know it was you and Mr. Brown. We know it was you and Mr. Brown. And so Mr. Glaspie, he's a smart, shrewd criminal right there. He's a known drug dealer and robber. He picked up on that and decided that Mr. Brown was the perfect patsy and decided to say, yeah, he shot the police officer, and I want my 30 years so I could testify against him. Now, Mr. Brown was picked up shortly thereafter, and from the moment he was arrested and through the dozen or so times I've seen him on death row, he's told me the same thing. He was asleep at home on the morning of the robbery, did not commit it. Now, that's a hard alibi to prove, right? But that's been our goal in the last 3 years, is to flesh that out and get the information that we need to show the court that he truly was not the perpetrator here. But let's go over the evidence at trial. Now, you'd think in a death penalty case in Texas, or anywhere, frankly, there'd be forensics, there'd be DNA, there'd be something really good, a videotape, to show you undisputably who the real criminal is here. Well, in Texas, that's not the case. It's probably the worst case on earth to be tried. Because in this case, the evidence was so thin. If you go a couple more slides. Right here is probably the best evidence that they had. And you won't be able to read the whole thing. But Mr. Brown's girlfriend at the time, her name was Erica Dockery, initially went to the grand jury, and she said, I got ready to go to my job and left around 8:30. She called her cousins, and they told me that the he in there, I'm not allowed to walk over here because of the video, but he was sick and that he was sleeping upstairs. That he is Mr. Brown. She gave a full, complete alibi to the grand jury, saying that on the morning of the incident, everything was business as usual. I went to work. I saw him there. I called my cousins who were at home with him. He was sleeping upstairs. Well, the DA needed something. The DA needed something from her because all they had was this cooperator, that gentleman you saw over there. And in Texas, as in most other states, you need corroboration for that evidence. So what happened was the DA began to pressure this woman, Erica. They charged her with perjury for saying these things, and they put her in jail. They set a high bail, a fact that the prosecutor was very proud of, knowing that she could never make a high bail. And 4 months she sat in prison. Her daughters were taken care of by her sister, and finally she just said enough. And she agreed, she capitulated, and finally said, okay, Mr. Brown told me in a jail visit 2 weeks ago, or 2 weeks prior to when I made that statement, that I was there. That's it. I shot anybody. I was there. So now you have a case with a cooperator's statement and an I was there. And then you add that to 2 other small things. Go one more. This is the only identification that anybody gave at the trial. Now, I know the video's here, but I got to walk over to show you this. This red square is where a witness said that they saw Mr. Brown. I'll come right back. I'm too animated. I'm a jury, a litigator. I got to walk around. That red square right there is where a witness said that they saw Alfred Brown on the morning of the crime. I'm going back. This spot here with the arrow, where that car is where Mr. Brown purportedly was. Now, I stood there, and there's no way you could see anything from that far away, more than 100 feet. It is so far away. It looks far away in there, and that's because it is. And the witness who purportedly saw Mr. Brown that day was expressly instructed by the DA not to mention how far away she was, because it would hurt their case. That only came out after we actually went and talked to her. So that's what you got so far. You have a cooperator, and I was there statement, and that. The last part of their evidence is phone records. Now, these really made me mad as a habeas lawyer on this case. The police officers ginned up these very clever maps. And what they would say is, based on cell records, cellular telephone records only, they could say where the call was made and, get this, who made it. A police officer testified at trial that, sorry, I got to go. On this day right here, April 3rd, 2003, at 8:26, Erica called Alfred. There was no testimony to that part. It just made logical sense because one was Erica's number, one was Alfred's number. There's no way to actually tell who did that telephone call. So there was a couple layers of hearsay, a couple layers of inadmissibility here, but this got to come into trial. So the jurors who we actually went and talked to, Craig was one of the ones who went and talked to the jurors, they gave a lot of credence to this. Well, if the police officer said they had a telephone call, they must have had a telephone call. So that's it, ladies and gentlemen. In Texas, you need four things. You need a cooperator, and corroborated by, and I was there statement, these phone records, and that 100 yards away. And that's all. So our job as the habeas corpus attorney is to take all of that trial record and try to prove to the court that he's actually innocent of these crimes. You can go to the next one. I'll get to that one in just a moment. So we got the case about 3 years ago, and I know this because my middle daughter was born 2 weeks before we got the case. And I didn't see her for a while after we got the case because I was in Houston all the time. But now we just celebrated her third birthday a couple days ago. So that's how long we've had the case. And I hope I'm not here still doing this when she's graduating from Catholic law. But if it is, that's what I'll do. I'll keep at it. At trial, Mr. Brown was confused, very slow, as I've said, and he didn't testify in his own defense. And if you could see the underlined part there, the only thing he said at the whole trial, on the top left there, he said, "These people trying to take my life away for something I didn't do this crime, man." And then again on the right side, "It's hard sitting up here. He's trying to let these people take my life away for something I didn't do." It was a cry for help, an exasperated cry for help. The judge promptly told him to shut up and sit down, and he did. And that's all he ever said. And this was sort of fast food death penalty. It took about maybe a week. I've tried civil cases where the amount in controversy is like $100,000, and that takes 2 weeks. I've tried misdemeanors that take 3 days. I've tried felonies that have caps of 20 years, and that takes 2 weeks. I just tried a case that Craig worked on. Sorry, Craig, I'm giving you all these platitudes, but Craig was the head paralegal on it. That took 6 weeks for a case where a guy got 5 years. And in Texas, it's 1 week, clang, clang, death penalty. So what do we do? Our job as the habeas corpus attorneys is to really scour everything, to look at all the facts, look at the record, talk to his defense lawyers, and go interview jurors and other people to find out, can we do something in this case? And I'm going to move again. But after much investigation, this is what we filed right here. It's a good visual aid. I did this in a bunch of schools. This is what we filed in October 2007. And it's a lot of stuff. This is a writ that's 350 pages of pure legal goodness, I like to say. And about 110 exhibits, affidavits from witnesses, affidavits from psychologists. Everything you could possibly want in this case, we did in that thing right there. I've condensed it to a 14-page summary, which you're welcome to come get afterwards. Now, I do have to digress for 1 second about my favorite story about this case. Well, one of my favorite stories. Craig, it's going to involve you again. I'm so sorry. You really shouldn't have come. Craig, I only trusted one person to file this writ. We were in D.C., obviously. And the case had to be filed in Houston. And I didn't trust FedEx or anyone else because I've heard all these stories, but you don't get the thing in on time, and the guy gets executed anyway. So the firm paid for Craig to fly to Houston to manually file it. And we had pulled an all-nighter right before that thing was just about done. And it was about 6 in the morning, after having worked for about 2 or 3 days straight. And Craig shows up with a suitcase, and we fill his suitcase full of writs. So he's traveling to Houston with a bunch of writs. And I give it to him. I say goodbye to him. I'm like, all right, here we go. And I was just about to go home, and I got a call from Craig. He said, Brian, I just got into an accident. And I was like, are you kidding me? Like, he's going to keep me from getting on the plane on time. And he was late as it was because that's a lot of work. And so I quickly rerouted him to National. I think he flew first class and got there on time. And thank you, Craig, for getting there on time. But that moment right there, I said, if this accident keeps us from getting filed, it truly is a matter of life or death. But he got on the plane and filed it. I think he went and saw a movie that day in Houston. So that's one of my favorite stories about the case. But what did all that mean? What is all that document? What is a writ of habeas corpus, and what do you got to do? Well, in state court, which is where we are still, you really got to file everything. It's sort of a use it or lose it type place. If you don't allege it now, you can't later allege it in federal court. So we had a big burden on us to file that big thing right there. Now, most cases you've heard in death penalty cases involve what's called ineffective assistance of counsel. And that's a big part of what this case was, too. You have to say that the trial attorneys who represented Mr. Brown gave him a constitutionally inadequate defense. They really, I'm a criminal defense lawyer. They really were bad. They really were, I think, they just gave up on the case. They tried to have the guy take a guilty plea. There was an offer of 40 years, which if you think about it, for a policeman killer case, 40 years is a pretty lenient sentence, which has to show you what the DA thought about their case, that it was weak, which it was. But our guy still wouldn't take the 40. And in Texas, he would have done about half of that. So think about it. If you're in his spot and you did this bad thing, wouldn't you just take the deal? But he said to his lawyer one day, I'm not taking it. She said, you should take it, even if you didn't do it. And he said, that makes no sense to me. I didn't do it. I want my trial. Now, at trial, there was really no defense. In opening, the defense lawyers got up there and said, our guy was merely present at the scene. He was at the next store. You saw the strip of stores. He was at the next store. Well, no one's going to believe that anyway. Who goes to furniture shopping at 8 o'clock in the morning? So that defense was never going to work. But then in closing, she says, no, he was at home. Well, what are they supposed to believe here? So they gave the jury no legal hook at all. And then we went and talked to each juror, all 12 of them, and they said it was as if they had given up, and they gave no defense. So I hope one day to have a retrial, and I will try that case, and I'll try it a heck of a lot better than the way she did. There was also a significant question of conflict of interest, and since we're here for ethics credit, might as well have a little quick ethics lecture. The guy on the right there a long time ago, Glassby, you can go back maybe 5 or 6 slides, that guy right there. That man right there, who testified against Mr. Brown, and really was probably the best evidence against him, even though he was lying the whole time. Tangentially, I went and saw him. He's doing 30 years at a much nicer facility than the death row place I have to go see my client at. And I looked at him, I said, you are just a liar. And I said some curse words too, but this is on tape, so I don't really know how much I can swear here. But and I called him a bunch of names and said, you're lying. And he got this little lump in his throat. And I said, it's okay, man. You don't have to tell me what you did. But I will find out, and you will be in trouble for this one day. And he sort of just got up and walked away. I don't know how much. It was fun to do. I don't know what it did anything, but he was behind a glass, whereas he wasn't going to hit me or anything. I could be nice and strong. So he was represented by a partner in a law firm that represented my client. So even for the 1Ls here, you got to know that that must ring some bell in your head that that's not right. So you have him represented by this man named, Craig probably knows, Alvin Nunnery. And then our guy was represented by a woman named Loretta Muldrow. Well, I think there's a slide I put in here where they are represented. Yeah, go to slide 11, a little further down the road. They have, as you can see from there, the same address, 909 Texas Suite 205, same phone number, and they were joint counsel on a lot of death penalty cases. They share a desk. I've seen it. And when you call their number, they answer as a law firm. So they're holding themselves out to the public as a law firm. And yet they are representing directly opposed interests in my case. My guy says he's innocent. Their guy basically ratted him out and said he wasn't. So we have what I believe to be an interesting hook here, a constitutional hook, as to why my client did not receive a fair trial, because he was represented by an attorney who labored under a conflict of interest. And there's some color to this, too. When I went to go to their office at 909 Texas Suite 205, I knocked on the door, and there was the sign that said the firm name. And the man, the one who represented the cooperator, was there. And I went and said, hey, I'm just looking for the Alfred Brown documents. And he said, okay. And then he walked upstairs and he went to go use the telephone. And I have to swear now, I'm sorry. He said, I could hear the one side of the conversation. He said, shit, they're here. What do I do? And he was talking to, the woman who had represented our client. And but he still gave us a box. And I talked to him about the case. And I said, so did you and Ms. Muldrow talk about the case? He said, yeah, all the time. I told her to take a plea. I told her my guy was going to say this, that, and this. And I saw on the table that they used, it really was a small firm. They had like a table like that, one chair on one side, one chair on the other. There were documents right there in open view. Now, I'll tell you, I work for a major international law firm. If there's even a sniff of conflicts, there's like lawyers from everywhere come say, you can't do that. Like today, I had to send a case away because like some client's son's client's brother had a conflict with what we were doing. So conflicts in a large law firm is a big deal. But conflicts in this case didn't matter a whole hill of beans, and it led to someone being executed, we think, with an attorney who really labored under a conflict of interest. So that was part of our investigation, is to gather all the facts, talk to everybody's lawyer, talk to everybody. And, I could probably spend another hour on the punishment phase of this case. I'm just going to give you a brief footnote about that. That's the next slide. Now, I could, as I said, spend a long time on this, but a doctor by the name of George Denkowski, who is what's now called Texas's Dr. Death, he tested Mr. Brown at the jail. When Mr. Brown was 11, he got an IQ of 71, which is right over the border of 70, which is the state line for when someone is declared mentally retarded. He tested a 68 before Dr. Denkowski. So that's pretty, well, not pretty good, but good in the standard of getting him to the state where he'd be subject to the Atkins defense, where you could not execute the mentally retarded. Now, Dr. Denkowski decided to give him 4 extra points for nothing. Just said he was anxious and depressed, so I'm going to raise his level to really 72 to 77. And he did that strictly and solely to get him over the level. I mean, no one could ever possibly think that you could just get 4 extra points just because you were nervous. Well, of course he's nervous. He's in jail. Of course he's depressed. He's on death row. Those things don't matter. He tested at a 68. That's his number. So we, at a big firm, we could throw money at this, and we hired every psychologist who has ever done anything on this field, and that's why that writ is so big. And every single one, to a point, said this guy's a quack, and you can't add 4 points or 9 points just because he is depressed. And so that's an excerpt right there from the writ. In the box there, the elevation of his full-scale IQ from 68 to 72 to 77 is unsupported. The methods he uses violate standardized procedures and thus make his revised data unusable. Fortunately, we are provided with Mr. Brown's unadjusted full-scale score of 68, one that should be used as the best estimate of his intellectual ability. So we have that plus a number of other scathing things from psychologists to say what this doctor did was wrong. So I'm confident that because of this, he'll be off death row sooner rather than later, because I do believe him to be a man with mental retardation, scored at a 68, and should not have been inflated, and should not be on death row. Now, Dr. Denkowski, by the by, is actually up for delicensing. We actually stirred quite a pot here. The Texas Board of Psychologists caught wind of what we were doing, and other attorneys who were also complaining. And now he had a 3-day trial as to whether or not he should keep his license. And I was told by the DA that if he is determined to be a quack legally, we all know he's a quack factually, but if he's determined to be a quack legally, they'll revisit the case. I said, well, what does that mean? And she said, well, there's enough in the record in this case to let him off death row. So I hope next time to come back to let you know that he is, in fact, off of death row. Now, that's just that point. Now, it is my mission now not to just get him off death row, but to get him out, because I firmly believe in his innocence. Now, let me tell you some of the really exciting stuff that we uncovered during the fact investigation. Let me see. Go to a couple more down. Oh, and actually go back one. To just one more. This was an affidavit from a juror, and in the bottom there, if there had been any reliable testimony from a doctor saying that Alfred Brown satisfied the definition of mental retardation, that could have made a difference in our verdict. And the point of this is you go talk to jurors to see what mattered, so then you could sort of weave it around that. The trial lawyers, the ones I've talked about, did a really poor job. They just said, well, okay, the doctor bumped it to 72. I guess that's what we got to live with. They didn't come up with enough information and evidence to show that he was, in fact, mentally retarded. And it would have made a difference, as you see from that juror's affidavit right there. Okay, now, factual investigation. probably the most critical part of any writ work is to just beat the pavement, go talk to people, and try to really figure out what happened. And I've spent many an hour at that VA that you showed over there, that really horrible housing complex. And I think we actually now know who the shooter is. And I'm going to tell you that now. Oh, good. We still have half an hour. Because now we're really getting to the good stuff. So the moment we took the case, I said, well, who's the third guy? I said, because, a DA is not just going to say, okay, you're right. I have to show really, who is the person who did this, to give them an idea that we got the really wrong guy here. So I took the trial lawyer out for lunch, and I said, who's the third guy? She said, I don't know. And I said, what do you mean you don't know? I was like, shouldn't you have been trying to figure that out from the beginning? And she said, well, we tried our best, kind of thing. And and I decided that answer was not good enough for me. So we got affidavits from almost every trial witness. And let me go to the one right here. This is one of the witnesses that said that they saw the person from that far away. Remember that other slide? The box there says, I signed a statement saying that I saw D, which is our client, hanging out with Sean and Ghetto, that's those two other guys, in the parking lot in the morning of April 3rd, the day of the crime. I identified Alfred Dwayne Brown as D when I saw him in a lineup. I was mistaken about D being with Sean and Ghetto in the morning of April 3rd, 2003. And what she goes on to say there, and in another affidavit saying that I was pressured by the DA to say that I saw Mr. Brown because that was going to suit their case. Well, you've got about 3 or 4 of these from the witnesses who all were at that grate right there saying that they saw him. So we've taken apart almost every eyewitness identification that there is. But then, really, I'm still struggling with who's the third guy, right? Because I want to be able to call the DA and say, you got the wrong guy, here's the right guy, go investigate him, let our guy off. But you need the third guy to be able to say that. So, go to the next one here for a second. When I told you that I went to go see their office, and I got the box of documents, we took it with us, and we flew home that afternoon. Now, I'm paging through this big box of stuff, and I see this 2-page handwritten letter. Now, being a former public defender, I got handwritten letters in pencil almost every day from jail. Sometimes good reading, sometimes not, most times just a little crazy. This one I decided to read, though, and obviously you can't read it from here, but there's some excerpts in the writ summary. This document right here is a blow-by-blow document as to what occurred that day, written by a guy who goes to see and talk to who we now know or believe to be the third perpetrator. And this whole letter shows how this guy shows up to talk to this third guy, and the third guy explains everything that happened in such detail that it has to be the guy. It's not just things he saw in the news that he can make the statement. It is the kinds of factual information that I knew from the moment I read it. This was a very live document. And the document ends there where it says Dobie, and that's our client's nickname because he's Doughboy, they call him because he's big. Dobie, that wasn't nothing but one big setup for you. And I read that on the plane, and I was like, telling him to turn it back. I wanted to go back to Houston that night to find this guy. But since then, we've been hot to trot for this one particular guy. Because I followed every lead in this letter. I read this letter probably 1,000 times. I could probably recite it word for word to you. I see it in my sleep. I know every fact that's in there, and I've now been able, through witness statements and evidence and just plain old investigation, this is a true letter. And I've shared it with the DA, and I think they are considering it pretty seriously. So now we have this idea of this guy. And I don't know that he did it, of course. I just have a very good idea that he did. His name is Gerald Doherty, or JD we call him. And so we have this letter, and we're all psyched about it. But then we get what I think to be the coolest piece of evidence in this whole case. Okay. On Alfred's birthday, we call him from the jail. We're in the office. He's in jail. And obviously. And we call him and say, hey, happy birthday, man. He's like, I didn't even know it was my birthday. He's like, well, it is. Happy birthday. And we put some money in his commissary account where he goes once a month to buy, underwear and food and, ramen noodles. And he's like, oh, thanks for putting the money in my commissary account because his family just doesn't care about him anymore. And I said, so what's going on? Anything good? He's like, well, they put Jobert next to me. And if you remember from that other slide, that's the guy on the left-hand side who had gone to trial and sentenced to death himself. And I said, oh, okay, cool. And I was sort of kidding. I said, why don't you ask him if we can come talk to him? Because I'd love to talk to him about what happened. And about 2 weeks later, we got a letter. And that's the next slide, I think. And this is a letter written by this man, Jobert, who writes to our co-counsel, hey, how you doing? I think you know who I am. Why don't you come and talk to us? So now you have it. Here's the moment, straight out of a crime novel. We go, and I have to say, Craig was with us right there, back there, for the most important part of the whole trial. Sorry, Craig, you were there. So we go to death row. Here we are. I'm sitting there face to face with this guy. It's in this particular one in the attorney booth. There's two chairs here, the guy there behind glass, and then there's a side one here where you could see him this way. So there's 3 chairs separated by a wall. And there's glass there. I've never even shook the hand of my own client. We just do it on the phone. So I pick up the phone, and this Jobert comes in, and let me tell you, he is just a crook. He is a criminal. He is a scoundrel. He is about as bad as you can get. I mean, tattoos everywhere, just bad guy. And I tell you, that's from my time in Brooklyn. I can usually suss out the good from the bad like that. He's bad guy. And so we're sitting there. We're sort of feeling each other out, sort of like a heavyweight fight. I'm just like, hey, man, what are you doing? He's like, how you doing? And we're just back and forth. And I say, well, I'm here. You asked me to come here. I'm here. What do you want? He's like, well, you know why you're here. I'm like, yeah, I know why I'm here. Why don't you tell me why I'm here? It was just a weird little back and forth. And I said, well, I think my guy is innocent. And he's like, uh-huh, yeah, tell me more. And I was like, well, we've done an investigation. We think we know who it is. And the guy sort of leans back. He's like, I'm not going to tell you. I'm not a rat, but why don't you tell me who you think it is, and I'll tell you if it's true. And I'm sitting there going, okay, I'll give it a shot. So I sat back. I said, it's J.D. And he leans back. I remember this moment, like, he tilts back. He's like, how you know that shit, man? I swear to God, Craig was there. He could tell you. And so for the next hour, he proceeds to tell us all the facts that are in that letter and all the things that confirmed all the things that we had thought before. And he tells us how J.D. is a football star. And this is where this case, it meets it's like John Grisham meets Boys in the Hood. They're trying to protect a football star who has a scholarship. And so this guy was supposed to be the next, great running back. And so they didn't want to get this guy in trouble. So they figured that guy can go off to the NFL or whatever he's going to do and make money while our guy languishes in jail. And if you go to the next, this is J.D. right here. He's up there in one of those things, one of those jerseys. I stole that. Sorry, Dean. Sorry, I didn't mean to see that. I stole that picture from the library of the high school where J.D. went, but I sent it back. I took it, but then gave it back. I did. I'm on tape. Great. That's great. So, but this letter, J.D. writes to Glaspie, to that guy on that side, saying, I'm feeling sick right now. I'm supposed to be running the ball for TSU. He had a scholarship to Texas Southern. Not wearing this bullshit orange. Hopefully I get out and I can do my thing. So he was in because, like a moron, a couple weeks after the crime, he committed an armed robbery and got caught driving away in a Mustang. And the victim said a guy sped away in a Mustang and was caught in a Mustang. So he was in jail. So now the whole plan was foiled anyway. But here's what's great. So now we have this testimony, we talked to this guy for about an hour. We know everything he told us about the crime, why they protected this man, and decided to put our guy as the patsy. And then we asked him, well, you prepared to put your money where your mouth is here? And he gave us a authorization to do an affidavit. And the next document, and it's here, written by our own CUA, Craig. That's Craig's handwriting, I swear. It's like the Craig love affair here. That says, in paragraph 3, Alfred Dwayne Brown was not involved in any way with the incident on April 3rd, nor present at the Ace check cashing store on April 3rd, 2003. That was as far as he was willing to go that day. I mean, he wrote it, Craig wrote it, he signed it, and now we've given this to the court. Obviously, we feel it's a pretty darn good piece of evidence. And that document right there, the Texas courts have they take it with a grain of salt. They say, sure, he's a convicted murderer. Of course he's going to say whatever he wants to say to help out his buddy. But that, compared with all the stuff that we've done in that voluminous, large writ, I think, to me, really seals the deal that this guy is an innocent man on death row. Let's see. Okay, now, we were fortunate to get this case from the beginning, because as I told you, in state court, you have to sort of use it or lose it. So we alleged a whole enormous thing there, that if we hadn't, then later down the road in federal court, you couldn't re-allege it. So we spent a ton of time on this, and we've preserved it all, in fact, because we want to go the distance, and I'll take as long as it takes to get it done. We had a video conference with the judge recently. He doesn't make me fly to Houston. We just have a little video conference. We're going to have a hearing in the summer, this summer, 2010, so it's coming up pretty soon, to litigate the issues of ineffective assistance of counsel, of the conflict of interest that I told you about, and of his innocence of the crime. And I'm hopeful as of that hearing, I at least get a new trial, because I do believe he's at least entitled to a trial with a conflict-free counsel and someone who's actually willing to really fight for him as opposed to the lawyer that he had, at a minimum. I mean, if I had my druthers, I'd say just set him out. Here's all the stuff we have. Just let him go. But probably not going to happen. You know, it's a police officer case, notoriety case. They're probably going to. My hope is to get a new trial, and I also hope, based on this delicensing of Dr. Jankowski, that he's off death row when we have to retry the case, so we don't have to face capital murder charges again. We also filed 2 DNA motions recently. It's not really a DNA case. Like, you hear a lot of Innocence Project cases where someone's in jail for 30 years and all of a sudden a kit comes and the guy gets exonerated and he walks out and everyone's happy. This is actually a lot harder because it really is not a DNA case. It is a witness case and trying to flip people who've said one thing to the other. But we did find some fingerprints were found at the scene, and some DNA was found on a shirt that we believe the test said it carries an unidentified male source. If it carries the source of this other man we've been talking about, that's a pretty good home run. And if his fingerprints are on the location, that's also a pretty good home run. We haven't got the results yet, but the judge ordered those tests, so we're hopeful about those. I think it might be it. Yeah, there it is right there. So there's we got the writ filed in October 2007, if you believe it, and here we are, March 10. It's still not being litigated yet. So these cases take a long time. You have to have the ability to go the distance and be patient, which I am not patient, but I want. And the DNA motion and then the delicensing hearing. So I've gone 45 minutes, which is a lot quicker than I usually go on this, but I wanted to have the opportunity to ask anybody if they had any questions or just see if they want to hear anything else about the case. But I do have one final anecdote, the case that makes me laugh. I went to death row once. Actually, I have 2 stories. Sorry, I'm probably going to go the full hour anyway. Every time we get to go to a death row, we get to buy him food. It's a unique thing that the attorneys can do. You have to bring $20 worth of quarters. So I come in loaded with $20 worth of quarters, and I get to sit him down and say, "What do you want today?" And I usually buy him $20 worth of stuff, and he eats it all right there on the spot. The guy's just the happiest guy I've ever seen. So that moment right there is sort of it's a little miracle amidst this very, very sad and tragic case. But here's one a day that really made me laugh. It's a really broke down bad jail, and I went to the restroom, and the faucets were very old, and I washed my hands, and the faucet broke, and water shot up like this, literally like, Craig, were you there for that one? No, okay. Water shot up like a geyser was shooting up, and so I tried to shut the door, and then water kept coming out. It was like something out of a bad movie, but water kept streaming out, and I'm on death row, not exactly the place where you just like evacuate people to clean a flood, and so water keeps coming out, and I'm drenched with water, no kidding. And I'm like, I can't believe this is happening to me in death row. So I step out, and water is like all over the floor. Family members who are there to see their loved ones are sitting on the table, on the chairs, trying to avoid this water, and I'm drenched. And everyone in death row could see this, and they were laughing their tails off. So you had like convicted murderers, bad guys, laughing at me for causing like this big flood on death row. And I said loud enough for everyone to see, and I bet you've never seen a lawyer all wet before. And everyone started laughing. And then I decided to buy food for each of the guys on death row because I felt bad. But yeah, man, it was crazy. And then so they come in with the mops and the things and that, and so we had to get everybody off the floor. And then it took them about 2 hours to finally mop it up. And then I got to go back and see Alfred. And I tell you, he laughed for like hours. We were sitting there with him for a long time that day. He's like, "Man, you caused a flood?" And I was like, "Yeah, we did." And then I came back maybe 2 or 3 months later, and every death row guy was like, "That's the guy, that's the guy, that's the guy." So I'm like famous for being the guy who caused a major flood on death row. But it has been a case that I think about every single day. He has a young daughter. I have a young daughter. It's an honor to work on the case, but it also hits me right here every day that but for us, but for a big firm stepping up and taking it and throwing money at it and throwing time at it, he'd probably be executed right now, which, if you think about that, is capricious, arbitrary, sad, terrible, unjust, anything you want to say. But it is my honor to do it, and it's my honor to bring on folks like Craig who have a desire to help out. I've had dozens of people help out in this case, and anyone here wants to help out in this case, come see me in the atrium, and I'll give you a research assignment. But thank you so much for letting me come here and talk to you, and everybody's welcome to come and chat with me outside. I have a standing offer that I've told Dean Miles, anyone wants a free lunch at my large, beautiful international law firm can come and grab it. And I'll tell you how I got to where I am, to let you know that CUA alums can do pretty cool stuff. Work at big firms, work at the government, do anything you want to do, and do work on really big impact cases that'll really help somebody out. So thank you all. Okay, so any questions now that we're sort of off the record? Do you want to chat with me in the atrium or anybody? Yes, go ahead, sure. Yeah. Well, I look forward to that day where I can get it expunged or just get him exonerated. What's good about it is he gets, I think it's $25,000 or $50,000 or maybe even more now for every year he was wrongfully incarcerated. So he's racked up a couple $100,000 already, which I'm going to put into a trust when he gets out to make sure that his friends don't steal it. And then yeah, I'll work with him to make sure that his record's clear. I'm sure he'll just be happy just to get out and and see his daughter again. But yeah, no, I mean, in the cases I work on, the non-death penalty cases, only certain classifications of crimes can be expunged. But this kind of case, you probably could get expunged if he was formally exonerated, for example. But sometimes you just have a felony record and you can't get expunged after trial. Anybody else? Yes, sure. Yeah. Well, that's actually a really good question. The other doctors that we've hired to look at this case said that the 68 itself was properly calculated. I personally want to subject him to retesting because I go sit with him for hours sometimes to teach him how to write the word cat. So, he may have gotten smarter in the 5 years that I've worked on the case, or 3 years I've worked on the case. I doubt it, frankly. I mean, but yeah, I do think we're going to keep the 68 because every doctor said that was properly calculated, but it's this bump to 72 that was wrong. He also tested at a 71 when he was 11, which is probably the best barometer of his mental status, actually, which is what we're going to play up. Even though the line is 70, there's a 2-point difference one way or the other. If it's 72 or 68, then you could still make that claim. So probably just go with the 71, but because you're right, the 68 computed by a quack. Do you want to rely on that? So it's a good question. Anybody else? Yeah, Professor. Oh yeah. To be honest, we spend more time talking to the DA. The court is. I'm actually not so sure the court's read that yet. The writs I've seen from other lawyers, other regular Texas lawyers, are like this much. So that's probably sitting gathering dust on the judge's desk. So yeah, we've worked the DA pretty hard. Every time I go, I try to glad handle her and try to tell her that she's got an innocent man and she should do the right thing, all those things. She did tell me about 6 months ago that she wants to find out the truth here, and I made sure she said it again so I can hear it. But yeah, but there's a culture in the Harris County DA's office of not believing defense lawyers, of believing people are guilty of what they've done. But she's actually younger and at least claims to have a more nuanced. She wants to find the truth if the truth is out there. So that's who I've really been working with. The judge I only talk to maybe twice a year on motions and scheduling. Anybody else? Yeah, go ahead.
I was wondering something similar to what Amanda said.
Yeah.
Have you contacted all of the victims' families?
About 18 months ago, I did a presentation here, and it was streamed on the law school's intranet. And somebody, a victim or a brother of the officer, contacted me, and she sent me an email basically calling me every single name in the book, and how could you defend that guy? And I wrote back a very nice email saying, please, I'm just trying to find justice here, but please, I'd be happy to speak with you and talk with you, but it hasn't happened since then. But I will tell you, one of the new steps that most habeas lawyers tell me to do is to reach out to the victims and try to get them on board. And when the time comes, if this DNA motion comes through, or if the DA is willing to back me, then I probably will go seek to move them forward. Maybe they will, stand next to me and say that it's okay to let them out. But yeah, that's an excellent question. Anybody else? All these professor questions, gosh. Oh, yeah, they had it the whole time. They had it 2 weeks. Well, it was about maybe 3 weeks before trial. Our guy, that's a real tragedy. Our guy does not know how to read or write. So he received a letter in jail. That letter he got in prison. Someone mailed it to him, and he got it in prison. He gave it to his lawyers and said, I can't read this. What's it say? Here, take this and investigate it. They did a very cursory investigation. Maybe I saw the notes, maybe like one or two phone calls. And it literally was in the bottom of a postal box, like a U.S. postal box. with the dust on it. I swear, it was like literally at the bottom of the box, the document that could save him. And that's one of our claims too, is that they didn't do a thorough factual investigation. That's part of our ineffective assistance of counsel claim. And I've subsequently asked them about it. Said, why didn't you do anything about it? She's like, I got letters all the time. I don't read every letter I got. I'm like, great. Just happened to miss the one letter that could have saved the guy, but that's okay. Question? Yeah, back there. Not really, no. Aside from me sending him sketchbooks, it's funny, I was in Target the other day, and I bought him and my 5-year-old daughter the same book to learn how to write. But no, it's really, he's on lockdown 23 hours a day. He gets to go out into a common area, which is very small, sort of not really a gym or anything, just an open space where he can walk around. He doesn't have a TV in his room or anything. We bought him subscriptions to some magazines so he can look at pictures. He likes cars, so I got him some car magazines. But no, there's no formal education component on death row. Yeah. Yeah, I believe so, right. In general population, which is, as you walk into death row, it's a pretty harrowing place. On the right side, there is the general population, which I see people milling around. Like I see inmates sitting at tables and talking. And then on the left side is where it's totally locked down on death row. So yeah, he would, and I hope he does. For the time period in which I do think it's going to happen very soon that he gets off death row because of his retardation. And if he has to sit in general population for a number of years while we litigate his innocence claims, I do hope he begins to get his life on track a little bit. Because when he gets out, I'll be his legal trustee when he gets out to make sure no one takes all this money that the state's going to give him. But I got to make sure that he's suited for life when he comes out. Yeah. Yeah. Yes, sir. That's another excellent question. Yeah, as a public defender, I would do night arraignments twice a month, about 100 cases a night, and there would always be cases like that, someone who I believe was slow or needed assistance, and I would ask the judge to put him in PC, protective custody, where they'd be by themselves. I probably would do the same thing here, but hope that he would still be able to get access to that kind of stuff. That's a really good question. Yeah. Sure. Yeah. Like a bar complaint of some kind? Yeah, I think we might. I certainly don't want her doing capital work anymore. She was ordered by the court to explain herself in an affidavit, and her description of the office was insufficient in my view. I think she was not being all that candid with the court. It's not I don't hold a personal grudge against her, but I may send the matter to bar counsel once the case is over. But right now, I just want to get the guy off, and hopefully that's a good constitutional hook. The problem with death row cases is you need some constitutional hook to get there. You can't just stand up and say, he's innocent. You got to have some factual basis and legal basis to do it. And this one I think is a good one. So if he labored under a conflicted counsel, that's a good reason to try to get him a new trial with me, who won't be conflicted. Anybody else? Feel free. And I'll be in. Okay, good, sure. Yeah, that's a good question. We had witnesses who have said in affidavits and signed it saying the police and the DA pressured me to say that. Now, if we ever get to a retrial, I certainly would use that. If they tried to bring those same witnesses, I would say, didn't you say in an affidavit that you were pressured by the police and you didn't really mean that? But aside from that, evidentiary, the judge has to decide what weight that he should give that. Whether these witnesses are just recanting now out of convenience or recanting now because they feel bad. But the DA has said in an affidavit that he didn't pressure anybody. So a judge is going to more than likely believe the DA, which is upsetting to me. But I looked this one witness in the eye, and she said, the DA threatened to take my kids away if I didn't say it was Brown. And I don't care. I said Brown. That's the kind of, and if you believe her, that's dramatic, and I believe her just because she told me and I have no reason not to. But a DA is going to get on the stand and say, I didn't pressure her. So then you have to think, you're the judge, who do I believe? And unfortunately, the DA is not under any sort of bar complaint either. I might send another referral when this case is over too. But yeah, that's a good question. Yeah. 2 questions. Come on, let's go. Go ahead. I'm just kidding. Go ahead. Yeah. Yeah, right. No, that's yeah. That's a very good point, and he is a definite follower. He was, in fact, the only conviction he has before this. I'm surprised no one asked about that. He's not a violent man. There's no violence on his record. The only case he has before that is a drug possession charge, a vial of PCP that belonged to that Glaspie fellow, the one who was in that slide right there. They were in a car together. Glaspie threw it out of the window, and then Brown copped to it and said he was his. That's his only prior criminal record, but that's exactly it. He's a follower. And, yeah, I do really worry he will get taken advantage of, especially if he has some notoriety there. Not that he wants to be known as, this guy who did this crime. But, yeah, we'll have to make sure that he's adequately protected. In fact, maybe even move to another facility altogether because he won't be on death row anymore, so he can go to any of the various state jails. Yeah. Yeah, I mean, one of the only folks I think in his life that has his best interest at heart is me and the legal team. So I'm going to make sure that he's counseled to, keep his mouth shut and just sort of wait till we get his hearing. But yeah, that's a good point. Yeah, sure. Go ahead. Yeah, that's a wild case. We sent our investigator to go talk to him while he was still in jail on that robbery case, the one where he was driving the Mustang. And to hear our investigator tell it, he was shaking him down and said, we got the goods on you, man. And J.D. basically told our investigator to go, F himself. That's exactly what he said. So I'm not going to say that curse word on the tape. And he's out now. And the ability to work at a big firm, I now know I can tell you where he is right now. Our investigator follows him around, knows where he is. He's selling drugs back in the neighborhood. I have not personally talked to him. I hope to one day. Our investigator got the sense that he was hiding something when he talked to him. And, if he's truly innocent, I will apologize to him. But after all the people I've talked to and all the stuff I know, I'm reasonably confident he's the guy. Yeah. 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 Yeah, he might be. In fact, the people who we've talked to have said they don't want to get involved if it means getting someone else in trouble. In fact, Alfred's own brother, who is his half-brother, has said, I'm not going to say anything bad about J.D., and this is his own brother. And so, yeah, there's a sort of a street code and a ghetto code. When I go to talk to witnesses, they're unwilling to talk to us mostly for that reason. So I do think I don't really care what happens after my guy gets released. If they go after the other guy, great. But it is going to be hard to convict him because you have that one cooperator on the record saying it was our guy, and now he'd have to sort of change it to saying it was the other guy. So that would be a messy trial without a lot of evidence. I mean, in fact, if the DNA evidence or the fingerprint evidence comes up, then we finally have some forensics in this case to actually show who was there. That might be the only way to get a sort of a certain conviction here. All right, those are all excellent questions. You're very well-trained legal students. I'll be in the atrium. Please feel free to come talk to me or send me an email or call, and we'll grab some lunch. Thanks.